It's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I'm blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property to be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Good morning, everybody, and welcome to the show. Today, our topic is what happens if an investor is in an accident. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on YouTube, Facebook, and X, formerly known as Twitter. You can find us at the handle @InRem Podcast. That is @InRem Podcast. Also, you can download our podcast. You can find it on Spotify, Apple Podcasts, or any of the major podcast platforms. Make sure to go there, download it. It's a good listen. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today deals with HOAs, and I'm going to address it from the standpoint of Arizona law, but I would encourage you that if you have an issue with your HOA outside of Arizona, that you research the laws of the state where that property is located and see what HOAs can do or allowed to do when it comes to their payoffs. So today is a discussion of what to watch out for with HOA payoffs. This is a constant battle that I see. It was very prevalent in the short sale days, and now it's coming back as unfortunately people aren't paying their HOAs because of other bills and debts and obligations that they're having to pay. Is okay. Now these HOAs are coming back and they have payoff numbers that aren't accurate or not appropriate. So a few things to watch out for. So the first thing to watch out for is whether or not the amounts listed in the payoff are barred by any statute of limitations. So in Arizona, it used to be that an HOA could only claim a lien for up to 3 years. So for unpaid assessments. So when I say unpaid assessments, I'm talking about amounts that are owed on a quarterly or monthly basis. They only are obligated to, or they can only claim a lien for back to 3 years. However, that's changed more recently. Now they go back 6 years. And so now you have to look here in Arizona to say, okay, are there any past due amounts, late fees, assessments, other charges that are over 8 years old? And if there are, not 8 years, 6 years old, and if there are, then they can't claim those. And those just are no more, and you're not obligated as the seller of the property to pay those amounts. The second thing to watch out for is the HOA including fines, or also referred to as monetary penalties, onto the payoff amounts. So what I mean by that is if you leave your trash can out past 5 o'clock on the day of trash collection, sometimes HOAs will fine you like 25 or $50. If you have weeds in your front yard, they'll fine you. If you have cars parked on the street when they're not supposed to be, or overnight sometimes, or things like that, they can fine you as well. And basically they levy fines and they put it on your account with the HOA. However, Arizona law provides that those fines, those monetary penalties, never become liens against the property until the HOA actually goes and files a lawsuit prevails in that lawsuit and reduces those amounts to a judgment and then records that judgment, at which point it will act as a lien against the real estate. So keep that in mind. That's very important, because until the HOA goes and actually actively pursues the collection of those amounts through a lawsuit, those numbers are nothing more, or those amounts are nothing more than a number in a computer. That's it. They have no other significance other than a number in a computer. And that means that the HOA cannot claim a lien. So if you go to sell your property and or you're a buyer even on property, and you get the payoff for the HOA, and you look and it's like, oh, we want $2,000 in fines and monetary penalties as part of this closing. No, they don't receive that. They're not entitled to hold up the closing for that. That should not even be on the payoff statement. Those amounts are nothing more than a number in a computer. And unless they've gone and reduced it to judgment and recorded the judgment, it's not a lien, and it should not show up on an HOA payoff. So be very careful when you get these HOA payoffs that the HOAs are limiting the amounts that they're trying to collect to just the amounts for which they have a lien, which is any amounts, any assessments and late charges on those assessments that were incurred in the last 6 years here in Arizona, and that it does not contain any amounts for fines or monetary penalties unless those fines and monetary penalties have been reduced to a judgment.
All right. Thank you, Sean, for the legal update. With that, let's go into a couple announcements. Join us this afternoon, every Tuesday at 3:00 p.m. Arizona time for the Creative Finance Collective. What is the collective? It is a group of attorneys throughout the country who focus in the space of creative finance. We get together and talk about what each other are seeing in the area of creative finance, talk about what different jurisdictions are doing, how to make each other's practice better, how to service clients better within the creative finance space. But we also take questions throughout the entire hour from listeners. So this is a real opportunity for you, the investor or the listener who wants to learn about creative finance from perspectives of lawyers that are doing this throughout the country. And really, when you talk about the niche that is creative finance, there's really only a handful of attorneys that are really focusing their practice in a serious way in the area of creative finance. So join us 3 p.m. every Tuesday. We take questions until we stop getting questions. So if you want to go for the entire hour, it's important that you're there and that you come loaded to bear with questions. Also, we're taking questions today in the final 15 minutes of the show. If there are any about our topic today, our guest and Sean and I will take any questions. So make sure to post them in the chat. You can do that now. You don't have to wait, or you can do it as the question comes to mind as you're listening. So you don't forget, we're monitoring the chat and we will be prepared to answer questions as they come. With that, we are going to get into our topic today. So our topic today is what happens if an investor is in an accident. Of course, we're referring to investor as you, the listener, who are investors that focus in real estate, focus on growing your business, so on and so forth. You as an investor are not immune to accidents any more than any other person or human is exposed to the probability of an accident, whether it be on your own personal time or while you're working. Regardless of what that is, we wanted to talk about that area of the law, what that means to you, how you should plan for that, and what do you need to do going forward with that information. And with us to talk about that discussion today is attorney Nick Strom. Nick, how are you?
Good. Thanks for having me. Glad to be here.
Yeah, thanks so much for being with us. Really enjoy having you. So give our listeners an idea, a little bit about you. Tell us about where you practice and what area of law you focus on.
Sure. I'm licensed in 3 states, here in Arizona, in Illinois, and then in the great state of Wisconsin. And I just wanted to actually congratulate Sean. I know that he recently became a member of the Wisconsin bar. Glad to have you. The more, the merrier. I'm a litigation attorney. I've been practicing for 13 years. My main focus at this point in my career is personal injury, but I have done other areas as well.
So, Nick, I know you're you're pretty prevalent on social media and you go by the term quad father. Why don't you tell our listeners what that means, what that's referring to?
Sure. Yeah, it was kind of an idea of my wife, but I am the proud father of quadruplets. I have 4 7-year-olds. They just turned 7 in December. So, along with a full-time legal career, I am a full-time dad, always running around. Sometimes I feel like an Uber service. But the quad father of accidents just relates to me having quadruplets and practicing in the personal injury space accidents. So that's where I came up with that.
So let's get into our topic today. Obviously, this is a show for real estate investors, but if you designate yourself as a real estate investor or a business person, obviously there's certain areas of the law that immediately come to mind that apply to you. When we say real estate investor, we think real estate law. So real estate law might heavily apply to you. I don't think the common person typically appreciates the fact that in any given moment of time, any and all areas of the law may apply to you given the factual circumstances that present themselves to you. So we're talking about injuries and injuries that can happen to an investor or a person engaged in this space. So let's start with this at the beginning. What area of the law is usually invoked when we're talking about an injury?
Usually what this area is called is torts, when you're engaged in an injury, or there's other types of torts as well. One important thing to know in the tort space, attorney's fees aren't necessarily shifted. I know a lot of your investors, or at least here in Arizona, are going to be familiar with fee shifting with contracts or with law. That doesn't apply in the personal injury space. What usually happens in an injury case with attorney's fees is that is collected at the end, a certain percentage of the award, assuming there is an award or a settlement. And that just depends on what the contract you sign with your attorney is. But the field of personal injury is within what we would call torts.
And I think what's oftentimes the case, correct me if I'm wrong, when we're talking about personal injury, we're talking about a situation where the party at fault committed some act of negligence. Maybe they weren't doing anything intentional, but their standard of care fell below what it ought to be, and they were negligence. Is that right?
Yeah, that's right. Mistakes happen. Maybe you're driving and you're looking down for some directions on your phone, or, maybe at a store, there was a spill of some perfume or something that wasn't cleaned up promptly enough. These sorts of things happen. But the person who's hurt shouldn't have to bear the burden of it. So yes, that's where the fault is assigned. Hey, the ordinary person, the usual person would not have, been looking down at their phone, or would have cleaned that up more promptly. So that's why fault is attributed to the wrongdoer.
So Nick, why don't you give us some common examples of personal injuries? Like what type of injuries, or circumstances would give rise to a personal injury claim?
Sure. The big one probably most people think about is a car accident or a truck accident. Someone runs a red light, or again, someone's looking down at their phone. But there are a multitude of ways you can get hurt. I mean, just think of anything from a dog bite, or you're at a store and you fall, or, maybe you're going in for a procedure, a medical dental procedure, and something goes wrong there. So there's any way under the sun that you can get hurt. It's an unfortunate reality of life, but that's what it is.
So when we talk about investors, one of the things that they're most concerned about, both on the injury side as well as the defense side, right? I mean, we talk about putting properties in LLCs and to be protected, but one of the things that they're most concerned about is an area called premises liability. So can you kind of go into what premises liability is, what to look out for, what happens if let's say an investor is going and looking at a property and they, step wrong and break their ankle or whatever the case may be, do they have a claim, or would somebody, who's on their property who does the same thing, would they have a claim? What's premises liability exactly?
Yeah, that's a great question. it's basically being liable for a piece of property or a building on a property. And there can be different ownership structures. Maybe someone owns the lot, but someone else owns the building. And maybe the injury actually happened like at a mall within a store. Because then it's like, okay, well, who's at fault of the three of those? You can see some really interesting things when it comes to ownership structures of different properties. But for the typical real estate investor, maybe with a single family dwelling, if your tenants are in there, yes, if there's something wrong with the property, there is the potential that you could be liable for their injuries. You need to basically, and again, different jurisdictions are different, but basically you need to maintain the property as a reasonable person would. You can't forego, regular maintenance. You can't, again, just like replacing a roof and things like that. Now, you can't be liable for things, you don't know about, or you had no way of knowing about. So I'm not trying to put all of your listeners into panic mode or anything like that. But, just being a good landlord is basically what you should be doing. And it sounds obvious, but I do see accidents in people's houses that you wouldn't expect.
Well, one area of premises liability that I think is always a concern, or at least it is for me, is the attractive nuisance. Like a pool or things like that. So, can somebody be liable if a trespasser comes onto their property, like a kid next door wants to swim in their pool, so they jump the fence and have a grand old time in the pool and end up, God forbid, drowning, and dying? I mean, is there a claim there?
I mean, there definitely can be. Every jurisdiction's different, but if you're and it's hard too with children versus what a reasonable adult would expect. But yes, I mean, you can be liable if there's something inviting on your property. However, the rules with a trespasser versus someone who's invited on your property, like a tenant, those are going to be different. If you want to get into specifics, I would definitely see an attorney in your jurisdiction. But yes, I mean, it's important to realize that there is a potential for liability in these situations. And, I always tell people consult with your insurance professionals, make sure you have the right insurance, not only for your property, but an umbrella liability can go a long way to helping real estate investors.
Well, I think about when I was in high school, an attractive nuisance could have just been a construction project. 2x4s and a half-frame construction look like a jungle gym, to a high school student, or someplace to go hang out at night where nobody else was around. I doubt whether, or don't know whether that would fall under that, but I know those are the kind of things when we think of being adults, what might be an attractive nuisance aren't always what attract the kids that shouldn't be on the property.
Yeah, speaking as a dad of quadruplets, it's amazing what kids will find their way into. That's for sure.
Another one I'm interested in, not because it's necessarily unique to investors, though I think it applies to investors, is the world of dogs and dog bites. We live in an age where everybody wants to bring their dog everywhere that they go for whatever reason, because they're man or woman's best friend, because they love it, whatever else. And I can see a situation where investors are bringing their dogs to the job site. It's all fine until it's not fine. Now, the law of personal injuries that applies to dog bites is a little bit different, and it's treated a little bit different, isn't it?
Yeah, it's strict liability. So if you have a dog bite someone, you're going to be liable on that, and the issue with that becomes damages. Arizona has a pretty clear statute on the issue. So yeah, I mean, obviously there's risk with everything. It's not something people think about, but yeah, taking your dog out, even if you think that dog has never bitten anyone before and is well behaved, you just don't know. So it is, important you take good safety precautions if you're taking your dog out. Maybe you have a muzzle for the dog or something of that nature. But yeah, it is a risk. And again, Arizona has strict liability for a dog bite.
So strict liability means that you don't have to show that you had any reason to know or knew that your dog was dangerous, and it doesn't even matter the breed, if you have that dog out and that dog for some reason, feels threatened by a human being and attacks that human being, and causes injuries, that's it. You're liable. And it's just
Yep.
now a matter of what are you going to shell out to compensate that person?
Yeah, absolutely. I've seen a case before too. I mean, you think a dog bite, you not a dog nip, like a dog bite. I've seen people have to get stitches from these sorts of things. And the dog from the reports was otherwise completely, docile. It just had a bad day and bit a woman, and it was awful. But yeah, so there's no like, oh, my dog was so great. No, it's your dog bit. It's your dog, and now let's calculate how much you owe.
Wow.
Is there any defense in the dog bite scenarios to provocation of the dog? The dog bits somebody in response to, somebody annoying or being overly aggressive with the
Yeah.
dog.
I'd have to look back at the statute, but that does I believe that is
It doesn't change the strict liability nature of it.
Right.
You're still responsible.
Right, you're still responsible for your dog. But there are certain exceptions, maybe if like a trespasser onto your property or something like that versus an invitee. So there is some nuance there, but yeah, the basic rule is if your dog bites someone, you are responsible.
So let's jump into kind of the next stage of this. We've talked about some common areas that investors might face either injuring somebody or being injured themselves. Let's talk about the first thing somebody should do if there's an injury. And this obviously probably takes a different focus depending on who we're talking about, whether it's the person who's caused the injury or the person who's been injured. So let's initially take this from the perspective of the injured party.
Sure.
And I know this is probably even further matters depending on the type of the injury and, of course, the severity of the injury. This assumes you can do anything after the injury. First thing that if an injured party should be thinking about, should they call the police?
Well, the first thing I would tell the injured party is try and just get in the right mindset. It's pretty shocking to get in an accident. I don't know if you guys have been in accidents, but all of a sudden you got to kind of do your best to assess yourself, see if you're hurt. Can you get up? I mean, has your car flipped over? Of course, again, the type of injury, it's different for different accidents. But yeah, I mean, you should call the police and get them out there and get a report to know what happens. If there's no police report, no official report, then it's going to be just your word against the other person's word. And sometimes that's what is reported in a police report, if both people say I had the green light. But it's important to get the authorities out there, get that thing documented, and then obviously get yourself treated as quickly as possible. Oftentimes the police will, when they arrive, they'll ask you, do you need treatment? How you doing? An ambulance will, depending on the accident, will come out too. But those are the first two things. I get the police out there and then get yourself evaluated.
What if I'm one of these folks that, prides themselves on never needing medical assistance, and I'm just going to gut it. I'm just going to gut it through, regardless of how severe my injuries might be. Very severe. I might be crawling off the scene. I might be, a variety of things that the average person would see as a serious injury. But you know what? I don't like doctors, or I don't do this. I'm just going to bear through this. Does that serve me well at all in terms of my injury? That kind of attitude?
Absolutely not. I mean, obviously, the toughness that you're kind of describing there, it's an admirable quality. But when you've been injured by someone else, you don't know necessarily what's going on right at that second, but what the long-term impacts could be. And if you're not able to get evaluated right away, what if something down 3-4 months down the line, maybe a year down the line, that was related to the accident that you don't know about because you weren't evaluated and you tried to gut it out? I mean, the vast majority of people in an accident probably aren't a doctor capable of evaluating themselves medically right there. And I bet you even a doctor would say, I need another expert. So I think the toughness and wanting to, grit it out it's admirable, but it's only going to hurt you in the case. And it could very much hurt your long-term health. And especially, what if people are relying on you? Maybe you have a spouse or dependents. They need you to get evaluated just so you can see, just to make sure that there's nothing wrong, especially for the long term.
So this is one that I've seen. I do a little bit of personal injury work. In fact, I work with you a little bit to do some of the pre-litigation files that our firm has. But this is the one thing that I see that people do wrong all the time, which is they're in an accident. It's the other driver's fault. So the question is do they then call their insurance company and report the accident?
I think the first thing you should do is talk to an attorney. Your attorney can walk you through the process. And I understand the desire to, inform you be a good customer, and put them on notice. But you really should talk to an attorney after being evaluated by a doctor, just to learn the process, and just from a economical standpoint, just so you don't have to deal with it. Like we deal with this all day, every day. It's just, do you really want to go through the insurance companies and deal with the doctors? No, just focus on getting yourself better. Go to an attorney, and we'll walk you through the process.
Yeah, and the problem that I see is somebody, it's clearly someone else's fault. You're at the red light, you're stopped, car plows into you from the rear. Like it's their other driver's fault. Like there's no question about it. And yet they run to their insurance company and then they say, oh, well, I want to place the claim. I want my vehicle fixed. And their insurance company is like, it's $1,000 deductible. Oh, okay. Here's $1,000. Well, then they go and they get their car fixed. And then they come back to us on the personal injury side. And they're like, well, I want my $1,000 back. And it's like, well, it's not that simple, because your insurance company has now a subrogation claim, and it's up to them to go pursue your deductible.
Yeah.
And then it's like, well, I'm out $1,000. I'm like, yeah, what you should have done, and we'll get to this next question. You should have either, like you said, Nick, gone to an attorney right away who would have told you, okay, to get your vehicle fixed, call the other driver's insurance company, and they're gonna take care of it, and you won't have to pay a deductible. Or if they don't have insurance, then we could talk about using your own coverage. But now let's talk about, well, what about the other driver's insurance company? At what point do you contact and let the other driver's insurance company know that you are a party, an individual that was injured by their insured driver?
Right. Well, again, it wouldn't be you, I would hope. I hope you were going to an attorney for something like this. But honestly, we put the other insurance company on notice as soon as possible, just to, so they stopped communicating with you and you can get on with your life and just focus on healing. But we put the other insurance company basically the first day we get a new case, and then we can coordinate with them, answer questions if they have it. Anything like that.
Yeah. And there's two types of claims that happen, and I'm probably jumping a little bit ahead, but I really want to hone in on this, because I think it's one huge mistake that people make when they're in an accident. There's two types of claims. There's your property damage claim, which means the damage to your vehicle. And then there's your personal injury claim. Well, most people need a vehicle right away.
Yeah.
They don't have time to sit around and wait while you go and get treatment and we get medical records and we do everything we need to do to process your personal injury claim. They need their vehicle. And there's two separate claims and two separate adjusters that are going to be appointed. One's going to handle property damage. The other is going to handle personal injury. The personal injury claim is going to take time. The property damage claim is you go to the other driver's insurance company ASAP, whether through an attorney or on your own, and you basically have them send you to a repair shop if your vehicle can be repaired, and then they pay for the rental car. You make them give you a rental car until your vehicle's repaired, And then you go, when it's repaired, you turn your vehicle in, and the, rental car company invoices the insurance company. You walk over to the repair shop, you pick up your vehicle, and they invoice the insurance company, and you're not out of pocket at all. Okay. You don't have $1,000 deductible that you have to pay, like if you place it under your own insurance company. And so I just kind of almost like a public service announcement, like, do not, if you're not at fault, don't place that claim with your insurance company. Go to the other insurance company. Now, that raises a question. What about giving a statement? Do you give statements either to your insurance company or the other driver's insurance company?
No, you don't. I would never, I almost never, probably never recommend it. You got to remember, the insurance company isn't, I want to say this as charitably as I can. The insurance company's business model is about paying out as little as possible. So any statement you give may come back to bite you. And again, if you haven't talked to an attorney, you might not know certain things. Maybe one thing I always tell a client before a deposition is, if you don't understand that question, you ask them to repeat it, and don't answer it if you don't know what they're asking. But you might feel pressure without having gone to an attorney, and you might just say something, answer something that you think they're asking one thing, but they're not, and you answer something wrong, or you might be inarticulate. So I wouldn't recommend giving a statement. You will, if there is a lawsuit, you'll be required to give a deposition as an oral examination in front of another attorney, but your attorney will be right there. You can ask your attorney questions. So I would not recommend giving a statement to an insurance company after an accident.
Well, and you mentioned before, Nick, just after an injury, you're in the throes of an adrenaline rush. You're in a blur, and that blur doesn't just last for a few minutes,
right?
To think that you're prepared to give statements one way or the other about this is really kind of assuming a lot and expecting most people to be at their best when they're not going to be at their best.
Yeah.
So it's problematic in a lot of different ways. Now, on this insurance question that you and Sean have been discussing, you guys have been discussing it within the context primarily of accident or vehicle accident cases. Does the equation really change if we're talking about another type of personal injury like premises liability?
No, I don't think it does. I think these are principles that apply across the board for injury cases. We talk about vehicle cases because, that's where, I need my vehicle to get to work. It's the most common. And that's where this property damage thing comes up. And, there's a little more to do with when your car's beat up, you gotta still provide for your family or drive to real estate, showings and the like.
So stepping forward a little bit, just following an accident, whether it's a vehicle or some sort of premises liability, slip and fall, whatever the case may be, if you're the injured party, we live in an age of almost 100% video and photographic surveillance in a sense. Everybody's got a phone, including this injured person. Should they be thinking of taking pictures of, assuming they're capable of taking pictures or videos of the accident scene?
Yeah, I like that, assuming they're capable, because again, they will, if you've been in an accident, it's a little shocking. You got to kind of get yourself together. But yeah, I mean, taking pictures of the accident scene, of the damage to the vehicle, things of that nature, it could only help. The insurance company is going to be taking pictures of the vehicle when it gets to the repair shop. So you might as well have your own documentation. So yeah, I would recommend that again, if you're capable of doing that.
Well, and the other thing is, it's not, we've had great success where our clients took pictures of the vehicle. And even though like an insurance company may play down their injuries, you look at the vehicle and you're like, there's no way you walk away from that crash without suffering, a concussion or, some soft tissue injuries that need to be taken care of. But also, I've encouraged clients before to take photos of like surgical procedures and,
Mm,
wounds that have become infected and things like that.
yeah.
And those photos add a lot of value to the case. I mean, I had one client who I knew was going to have surgery as a result of the accident. And I had her have the the nurses that were in the operating room take photos during the procedure with like her leg open,
Wow.
like where you could see inside and whatever. And, you get that into a demand letter to the insurance company. You're like, yeah, that gets in front of a jury. Like, that this is what they had to go through, even though they were, asleep and whatever. It just looks gruesome. Right.
Yeah.
And so, it's those types of things all the way through the process where you have to think about documentation, right?
Absolutely. No, that's a really good point. Yeah, definitely do your best to document everything. Don't post on social media or anything like that. But yeah, keep your documentation and get that to your attorney throughout the case, and that's a very valuable thing.
So, in the same vein of discussing what to say or not to say to an insurance company or whether to say anything, again, assuming you're in a state where this applies to you and you're capable of being conscious after an accident and aware and all these other things, there's other third parties that are likely going to be involved in some sort of injury or accident scene. And mainly I'm thinking witnesses, just bystanders that are there to see what's happened, that are going to come over and lend a hand to help you out. Just good citizens being good citizens, and medical personnel, whether it's an ambulance or something else, or immediately after the scene at the hospital. You are going to be exposed to other third parties that are now witnesses in one way or the other to an accident scene. They're either firsthand witnesses that saw what happened, or in the case of medical personnel, they're witnesses to your injuries and to things like that. But they have kind of a stake in the case, so to speak, if I could say it that way. Should an injured party be careful about what they say to them, to those types of third-party witnesses?
Yes, absolutely. There's a principle in the law, basically, that if anything you can say can be used in court, it's called an admission by a party opponent. So whatever you say to personnel or witnesses, that can come back against you, and you need to remember things can be taken out of context. And I'm especially with those medical records. I've seen cases where defense counsel will come back with medical records and say, "Oh, injured party was at a wedding all weekend," or something like that, and it's like, "Oh, she was well enough to go to a wedding, right?" Well, she was at the wedding, but she was in the corner the entire time, So things like that can come out in a bad context. So yeah, I don't want to necessarily be saying be guarded or don't talk at all, but just be cautious, be articulate, and only say the things that need to be said, and say it in a proper way. Be mindful.
What about when you're talking to medical personnel, both at the accident scene as well as, when you go to your doctor? Obviously, you have to be honest, but we know that everything that you say to that medical personnel, and even sometimes stuff you don't say, or they might take it the wrong way, it's going to be in a report. So
Yeah.
what should you be telling medical personnel about your injuries? How should you describe them? What kind of conversation should you be having with them?
No, that's a great question. I do like you have to be honest. And I think you'll agree, even outside of the personal injury space, the only thing that's going to destroy your case, or one of the only things, is starting to lie. If you're not honest, it's going to just crush your case. But that goes both ways, right? So you don't make up injuries, but you also don't downplay your injuries. Like kind of Andy's example, the tough person going through, like, you don't want to downplay your injuries, or you tell your doctor, oh, it's not that bad, but you're not able to sleep at night because the pain is so intense. I still got through it. No, you just tell it like it is. If the pain is a 7 out of 10 and you're having trouble sleeping, say it. Don't downplay it. Just be honest. That's all you have to do. And and of course you might forget something or whatever. That's fine. But just be honest. Explain your injuries and your pain exactly how they are.
So let's move to kind of post-injury, and the victim is in the healing process, and they're starting to gather how they've been damaged and injured by another person, and they're trying to calculate that. In a personal injury action, what type of damages is the injured party entitled to?
Sure. So the main theory here is the injured party needs to be made whole. So they need to be put back in the position they were before. Now that's difficult with an injury because you can't go back to not being injured and, forget, wipe your memory clean of all the pain and all the time you had to do it. So there's a few things. Your medical bills, that is something that you should be compensated for. In personal injury, there is something called pain and suffering, and that's that number to give you for your pain, for the inconvenience of having to constantly go to the doctor and all that. We can't make the accident not happen. Everyone would choose that if we could, but we can't. So the best we can do in the law is a number. And that's what pain and suffering is. Lost wages, or maybe things you had to, lost wages. Yeah. If you miss work, if you can't go in, you're hourly, that's easy to count, right? I was off these many days, whatever. But maybe for your real estate investors for non-W-2, that's going to be a lot harder. Well, I couldn't hustle around as much. I couldn't make as many deals. Well, the insurance company is going to come back and say, well, the market was down, so that's going to be hard. So it's important to kind of have a way to evaluate, your real estate income and how much would be lost. You get reimbursed for things out of pocket. If you're traveling to a doctor, you should get the mileage back for that. If you're a small but mighty real estate investor, maybe you mowed the lawns of you have a few properties and you take care of the maintenance and that. Well, if you're injured and you can't do that anymore and you have to hire someone, then, I would be asking for reimbursement for that. So that's a list of some of the things you can ask for. But again, the theory is you want to be made whole. You want to be put in the same position or as close there to as before the injury.
Let's talk about personal property damage, because I think it falls into two categories. So the first is damage to your vehicle. How is that calculated?
Well, usually there is an evaluation by the insurance company. Sometimes, if the vehicle is really beat up, it could be a total loss. And then sometimes, it's just a dent repair, how much ever that costs. And then the insurance company pays for the repair. So it kind of depends. And there are different types of insurance policies. Check your insurance policy, meet with an insurance professional, make sure you understand your coverage and you have all the coverage that you want and can afford.
Well, let's talk about the situation where the airbags deploy, because that means that the car is going to be totaled. If the airbags pop, it's going to be totaled. So now the vehicle, it can't be put back together again. What does that mean as far as your compensation? Like, do you get to go out to the new car lot and be like, oh, my car is 5 years old, and yet you're going to stroke a check to the auto dealership for a brand new, same make and model, but 5 years newer? How does that work? What do you get paid if your car is totaled?
Right. Well, if your car was worth $10,000, you get $10,000. If your car was worth $100,000, you get $100,000. But it's not like, my 12-year-old, truck just got hit, so now I'm going to go buy a brand new Tesla. You're not going to get compensated for that. So that's just, and I mean, if you think about it, that makes sense, right? You're going to get the approximate value back of what you've lost. You want to be made whole. You want to be put in the same position you were prior to the accident.
So it's like, just, look at Kelley Blue Book, look at what's out there for sale, and come up with, okay, if I sold this vehicle in this condition with this mileage and this particular, make, model, and year, this is what I'd be looking at for a check that they're going to cut for you.
Yeah, more or less. Yeah, that's a good way to summarize it.
And then what about other contents in your vehicle? So, I've had a client, I'm kind of into golf. And so every once in a while, I have friends of mine who play golf who are injured in car accidents. And I had one whose golf clubs aren't cheap. It was in the trunk of his car slams into it and like shatters a bunch of the shafts and other things on the golf clubs, destroys the bag. How do they, what happens there?
It's harder. I mean, do you have receipts for those clubs? Like, do you know when you bought them? Because it's the same sort of principles going to apply. But I will say personal property is a lot harder. People all of a sudden I've seen some cases where they had some really expensive things in the car that was lost. And after it was towed away, it was stolen out of the car and stuff like that. But it's harder to prove the value of personal property, right? Because I mean, maybe golf clubs are a little easier. We can find that, but what's the value of a, I guess dating myself, and a 3-year-old iPod when those were new, well, how do you really do that? So yes, you can request compensation for the personal property, but that is just going to be harder because how are you going to document it? Do you keep your receipts? If your golf clubs are 5 years old, are you going to be able to do that? So it's a little tricky.
So there are times where third parties are going to have claims, even though they weren't the ones in the injury. And we call that in the tort world loss of consortium. Can you explain loss of consortium to us, Nick?
Sure. So like, let's say for instance, you're a married
in as much detail as possible.
No, I certainly can't do that. So if let's say, you're driving home, Sean, and get in an accident, and you are always responsible for making dinner or whatever, but now your wife has to do that. Well, then she would have a claim for all this extra work she's had to do to make dinner, or, maybe, you're the stay-at-home parent and you're hit, and now the other parent has to drive the kids around, take them to school, and that sort of thing. Those are the types of things that you might be able to get a loss of consortium for. And there are others. And if you have further questions, you can certainly call an attorney and talk to them about that.
So, Nick, another issue that I'm thinking of with regard to damages is, let's say I'm injured and I just pay for awesome insurance out of pocket, health insurance, that is. So I get injured. I don't have to come out of pocket at all. I paid for great coverage. Maybe I don't even have a deductible with my health insurance. It's all paid for. Does that mean I don't get to recover any of my medical bills because I had great health insurance coverage?
No, that's a great question. And you're obviously in a great position if that's your case. Usually isn't, but no, what would happen there is you would still pursue the case. Your medical bills, your insurance provider would have the right to be reimbursed for what they paid. The theory just kind of being, well, you already got this paid for, so you don't get paid again on top. That's not being made whole. Your insurance company should be made whole. But you would still get to pursue damages for those other things we talked about, for like pain and suffering, lost wages, anything like that. So you would still be able to maintain a case. It's just how the recovery is allocated would be different.
But you still get to add your medical bills into the claim that you make against the other driver's insurance company. It's just once you recover it, then you have to figure out, do you have to reimburse your insurance company? Do you have to reimburse the medical provider? Those types of things have to then be decided, where you might not be able to keep all of it.
Yes.
But you still can claim it. So if your insurance company pays let's say you have $100,000 in medical expenses and your insurance company pays it all and you don't have any out of pocket, you can still claim the $100,000. You just have to figure out once you get that money, who gets what piece of it. Is that correct?
Yeah, no, I thank you. That's a more articulate way of saying it. Thanks for clarifying. Yeah, that's absolutely right. You can and should claim it back, but again, your insurance company might say, "Hey, we need to be reimbursed for what we paid out." But yes, you absolutely can and should ask for that.
So we spent a little bit of time earlier talking about how everybody's got a phone and how everybody 24 hours a day, 7 days a week is using their phone, it seems like. So you know where I'm going with this. I want to talk about social media.
Mhm.
What should somebody who's been injured do when it comes to social media or not do?
Um, I would say don't post anything about your accident. If you want to shoot something out saying, I was in an accident, please keep me in your prayers, maybe something like that. But other than that, I would just shut it down and not use it. Again, like I said before, there's a principle in the law. Anything you say can be used against you. The insurance company is going to comb through your social media post and they're going to find everything you say, and sometimes they're going to misattribute things. I had a client once where she posted some pictures after an accident, like at a beach, and like maybe they're mountain climbing or something. But she was like, "These are from 5 years ago." Like, what? Why? And I'm like, "Yes, I know, and we can explain that in your deposition." But then she had to explain it in their deposition, and you should just know absolutely everything you put up there, and just even if you're not in an accident, just remember everything you put on there is there forever. So I would not talk about my accident on social media.
Well, in the personal injury space, I mean, both Andy and I have seen clients literally torpedo their case because they post what they think are just harmless photos, harmless, posts about their lives, like, oh, I'm in the Bahamas on vacation. Oh, I'm climbing, South Mountain. I'm doing this, I'm doing that. And all of a sudden the insurance company is looking at it and they're like, well, weren't you going to a chiropractor for treatment? Or weren't you, going to a medical doctor for treatment and physical therapy? How are you doing all of this? How are you on vacation? How are you hiking? How are you doing this? And literally it's torpedoed their case. Like there's no getting back from that. And it wasn't like we had your case where it was like, oh yeah, these photos were 5 years old.
Yeah.
These are like, yeah, they did it that day, and we're kind of hosed.
Well, yeah. And even if you are going on a vacation or something, you're flying across the country, maybe to go see family, right? I've been in depositions where the insurance company's attorney's like, okay, so you went on vacation. Okay, so how'd you get there? Oh, you drove there. Okay, who packed? And you go through your day and you think about all the stuff you're doing. Okay, so you were able to pack. You were able to sit in a car. You were able to get through airport security, which we all know is just a pain going through an airport. Wait in the airport, sit in the small plane, So they're going to try and ding you on all that stuff. And, why let the insurance company know about it? Like, why put that out there? So I just think it's not wise. I'll put it that way.
So Nick, explain for us the process, kind of start to finish, of a personal injury claim. How does it begin? How long does it take? That kind of thing.
That is a very popular question when I'm talking to clients. Now, these are just generalities. It varies from case to case, obviously. But essentially, after you're in an accident, you got to go and get your treatment. And nothing really is going to be able to be negotiated with the insurance company until you're done treating. From the time of an accident, you have generally 2 years to file a complaint. And that's known as what's called pre-litigation. So in an ideal scenario, you're able to get all your treatment done prior to litigation, prior to the 2-year mark, and you're able to wrap it up within those 2 years. Totally depends on the severity of the accidents, the availability of doctors. During COVID, a lot of things slowed down and got backed up because certain appointments couldn't be made, that sort of thing. Stuff happens. At the 2-year mark, you have to file your complaint. And, again, are you still treating? How severe were the damages? But after a complaint's filed, it could go on for another few years, potentially. That's on the, far outside. That's probably not going to be most cases. But it could go it can go for several years after the actual accident.
What about if the party who injured you has no insurance? What do you got to do now?
Yeah, well, that's a great question. So, and again, different jurisdictions are different, of course. The first thing to consider if they don't have insurance is, well, who hit you? What, was Jeff Bezos driving and he just let his insurance lapse? Because then you're fine. You still have a cause of action against him. He has plenty of money. He can pay for your damages. Now, probably not happening. If there's no insurance, maybe this person was too poor, so they don't have any assets. You're not going to be able to sue them and get anything from them. So yeah, what do you do? Well, in Arizona, we have what's called uninsured motorist coverage. Your insurance company has to give you the option of getting that, and you should always get it and always opt in, because what if you're hit by someone without insurance? And then basically what it is you can proceed against your own insurance company for your damages. It's unbelievably good thing, if by no fault of your own you're hurt, and you have all these damages, it's good that you're able to go with your own insurance company and get these things paid. So there is a provision in Arizona. Check with your insurance professional, make sure you have the right coverages, the right amounts, and that you have underinsured and uninsured motorist coverage.
Well, you just mentioned underinsured. So let's talk about that. So the first scenario is you're hit by somebody who doesn't have insurance. Well, what if you're hit by somebody who doesn't have adequate insurance? In Arizona, our state minimum is $25,000.
Yeah.
Most accidents and injuries are going to be pushing or exceed that. So what does underinsured coverage mean, and how does that operate?
Yeah, that's a great question. It's very similar to the uninsured. So let's say you're in an accident, you have $100,000 in damages, but the other side's insurance policy is only $25,000. And of course that insurance company's like, here you go, because I don't owe, anymore. It's the same principle as if Jeff Bezos hit you and he, let his insurance lapse. If they have additional assets, you may be able to pursue those assets. Maybe, and you'd go after them personally and say, look, you are irresponsible. You were underinsured and you have all these assets. That's your problem. The overwhelming majority of the time, that's not the situation, right? They have the 25 policy and they're not going to be collectible. So that it's the same thing. You go with your insurance policy and you can recover the amounts that you should have been able to recover from the at-fault party. And I should note your you underinsured and uninsured motorist coverage are going to be the same policy limits that you have. So if you have a 100, 300 policy, it's going to be the same for your UM and UIM claims.
So following the same kind of analysis, if I'm a real estate investor, if you're representing an investor, one thing, given all of this information, it would seem to be important is to reassess their own insurance policy to make sure that they have particular coverages. I'll just kind of jump on one of these right away. I know from experience that there are a lot of cases where parties aren't properly insured. Sean mentioned the 25,000 state minimum coverage. You sneeze the wrong way in a hospital and it costs you 25,000, right?
Yeah.
There's almost no claim that doesn't bump up against that. So anybody who's doing that is going to run into an underinsured kind of issue. These types of features to make sure are on your policy, I think are enormously important. What are some other things that you would recommend that an investor or individuals look at with regard to their own insurance policies to really prepare for the possibility of them causing an injury?
Yeah, I think that's a great thing to focus on for your podcast. Just all the investors have tenants, or a lot of these real estate investors will have tenants. And what if someone's injured on their property? I would definitely meet with my attorney and then an insurance professional. Check your liabilities, like you were saying, your liability coverage. Have them explain to you exactly what is covered, what isn't covered. You might find some surprises there. And then the one thing I always encourage everyone to do is look at an umbrella insurance policy. Make sure you know what that is, and make sure I have one. I say to everyone, I think everyone should have one.
All right. Well, Nick, thanks so much for being with us. It's been great information. Tell our listeners how they can find and connect with you.
Sure. Well, I'm on pretty much all the social media platforms as Quad Father of Accidents, so you can look at me there. We got some cute pictures of my kids and some videos I do. Also, I'm on the firm website. You can reach out that way, and yeah, I look forward to hearing from some folks.
All right, Nick, thanks so much for being with us. Look forward to doing with you again.
Thanks. I had a great time.
All right,
Thanks,
have a good one.
You too.
All right, everybody. With that is our show. Make sure to join us next week. Next week, we're talking about the Corporate Transparency Act with Natalia Olek-Rice. That will be a really good bit of information, as we've been getting a lot of questions from viewers and interested parties about that act, what that means for LLCs, what that means for reporting. So make sure to join us next Tuesday. We'll be going through it, and we'll see you at 3 p.m. at the Creative Finance Collective. Everybody, have a good week.
Have a good day, everyone.